Good afternoon, everyone. Welcome to our Friday Live at 5 with Anthony and Lianne. We're just going to wait a couple of minutes before we do formal introductions, or a few seconds while we let people jump on. How are we doing today, guys?
And to you?
Yeah, well, thank you.
Yeah, good, thank you. We'll just hold off for about a little bit and let just people jump on, and then we'll do some intros. It's been a lovely day down here in Dorset today.
Absolutely.
Yeah, a bit windy, but very sunny.
Yeah, sun has been shining. Okay, so we do those introductions. Okay, so good arbor. I'm Rob Emery from Power Bespoke. I'm one of the property negotiators. Today we're catching up with Anthony and Lianne on probate and property. Let me hand over to you guys to introduce yourselves. Anthony.
I'm Anthony Weaver. I'm a partner in the firm Coles Miller Solicitors in Broadstone office. I specialise in wills and estates, anything to do with private client work, we can help with. My colleague Lianne.
I am an associate solicitor at Coles Miller Solicitors in our pool office, and I specialise in residential conveyancing. So that's sales and purchases, assets, transfers of freehold and leasehold property, and sometimes new builds and shared ownerships.
Okay, cool, fantastic. Welcome today, guys, and thanks for joining us. Like I said, today we're chatting around probate and property. So if you think anyone you know may get some benefit from this, would you mind sharing it? If I could get a couple of thumbs up so I can make sure everyone can hear us. So let's get those comments in, please. Let's see if people can hear us. All right. Okay, so we might as well crack right on. So Anthony, if you want to take the stage and just intro about a little bit about the probate side, and then Lianne into the do's and don'ts of selling a property.
Yeah, absolutely. So my first thought, if we're talking hypothetically about a client who, somebody's passed away, that person owns a house or a flat, is that you're likely to need legal advice. You may well need a grant of probate. And the first thing I would do would be to telephone a solicitor specialising in wills and estates and find out what the legal steps need to be. They would probably want to have a look at your title deeds. They would need the paperwork to do with the death certificate, whether there's a will, and possibly details of the estate. They should be able to confirm the legal process that you will have to go through in order to be able to successfully sell that property and reach the exchange of contracts. There's potentially a whole load of preliminaries that need to be dealt with, including probably getting a grant of probate from a court called the probate registry, and that can take weeks or months. And so it's much better to get that underway, particularly at the moment. So yes, legal advice first is a good first step.
Okay.
Yeah.
All right, and Lianne, over to you. Some advice on what to do, and I suppose what not to do when you're selling a property through probate.
Yeah, so normally we would then get involved once the property's usually on the market already. So someone would just give us a ring and ask us for an estimate for charges, and probably just have a chat with us about what they need to do, what paperwork they'll need to get ready. And ordinarily the solicitor would then ask, where are you with the grant? Because it's always a good idea to see how far along you are to monitor expectations with everybody. We would then open a file and send out quite a bit of paperwork. There is quite a bit of paperwork with a probate sale. That will involve a property information form, a fittings and contents form, and a leasehold information form if it's a flat, for instance. But a lot of the time, buyers will be aware that with executors, they haven't owned the property themselves. Sometimes they won't actually know anything about the property. If it's professional executors, for example, they're not going to be able to answer any of the forms because ordinarily they haven't even seen the property that they're selling. So we try our best to talk people through the paperwork, and you answer as much as you can, but you're not expected to answer every single question. A lot of the probate properties are sold as seen. So ordinarily we just scratch through the fittings and contents form, or sometimes even say come to an agreement with the buyer as to what they would like to buy or keep, and then the rest is cleared. So there's a lot of work to do with talking with your solicitor, coming to an agreement and knowing a way forward before you start really pushing forward all of the case. So trying to get the paperwork sorted at the beginning is kind of key for a probate sale, because then it will save you a lot of inquiries coming in. And often at Coles Miller in particular, we make sure that when we send out the contract pack to the buyer's solicitors, we make it clear it is an executor sale, there's limited knowledge, and please bear that in mind when you're raising inquiries, because you can raise as many inquiries as you like, but unfortunately, if the executor has no idea, they're not going to be able to answer them, and it will just draw the process out. So I'd say getting the paperwork sorted at the beginning is the most important part with a probate. Part of that is having a chat with the solicitor to make sure that the property is registered to start with. About 95% of property in England and Wales is registered now, but obviously the portion of properties that aren't registered do tend to go up when it's a probate sale, because compulsory registration often hasn't then happened for older properties and people that have lived in them for a significant amount of years as a nice family home. So your solicitor will be able to find that out quite quickly for you from the land registry. So they'll be able to tell you whether it is or isn't registered. And then if it isn't registered, you have the fun job of trying to track down your title deeds, which hopefully someone knows where they are. They're probably with the solicitors who bought the property, or maybe even the bank who used to have a charge on it, depending how old that charge would be. So that's part of the paperwork side of things. The don'ts, I would say, is probably don't put the property on too early. I have had instances of people phoning me for a quote and then the next day saying that they've actually sold the property, but they haven't put probate in yet. So that can then cause a bit of a problem with buyers getting all excited and then being disappointed that they're going to have to wait. Don't start talking about completion dates until your solicitor says that they're quite far along the process to actually have that discussion. A lot of expectations can be raised by talking about dates, and then unfortunately it's the legal side that hasn't quite caught up with those expectations. So you don't want to disappoint people by accident. And just don't be afraid to have a chat with the solicitor, because they will be able to tell you exactly where they are with the legal side. The estate agent might be saying where everyone would like to be, but sometimes that's just not possible. So have a chat with your solicitor. Don't be afraid of them by any means. We do tend to talk English these days, and we'll be able to tell you exactly where we are with things, and we are trying to be friendly in general.
So maybe on the title deed, is it possible maybe to prep that early on in the stages when you're preparing your will, for example?
So if you're not sure if your title's registered, give a solicitor a ring. We have access to land registry, and it's usually just a simple address search. We can tell you if it is or if it isn't quite quickly. And we can even put in for what's called a voluntary first registration for you. So if you do know that your property isn't registered, or you'll find out it isn't, and then you find out your title deeds are with another firm of solicitors, you can get them sent over. We then go through them and actually put your title together from those title deeds, form the title, and then we can send it off to the land registry and actually get it registered, which is good because it makes the sale process quicker when it does come to be sold, which may or may not be a probate sale, depending. But it also is good from the point of view that it stops fraud being quite so easy, because the title's already registered. It's then harder for you to commit a fraud by saying, oh, the paperwork went missing, but I've owned this property for so long. So I would definitely suggest, if it is unregistered or there's a potential for it to be unregistered, find out and then do a voluntary first registration. So it's a smoother process when it comes to a probate sale, but also you have that safety net as you're going forward as well.
Super. Anything to add to that, Anthony?
Yes, I mean, it's probably worth mentioning that the probate registries have been changing their procedure. They are consolidating and closing. This process has gone on for several years, but it's worth flagging with people that it was only last year that there was suddenly a big problem when they decided that all of the probates would be issued from one building centrally that would deal with all of the probate courts. And it created this huge kind of backlog and a massive delay. We had, I think, one that took 9 months from going off to the court to come back. And that's a procedure that used to take 2 weeks reliably over the last 10, 15 years. So we can't emphasize enough, get the probate advice first when somebody goes. If we're not careful, you'll find out that you've got this open-ended delay whilst the probate is dealt with before you're legally able to exchange contracts. So that, yes, you will lose your credibility. Speculative buyers will see that this property is sitting empty on Rightmove or wherever, and you will lose credibility because it's sitting there. It doesn't seem to sell, and you'll go to the bottom of the search list. So delay putting the thing on the market until you have a grant of probate, or a solicitor confirms you don't need one, or it's over the line.
Okay, cool. I just saw some questions coming. We'll answer all the questions once we've gone through all our topics. Thanks, Glenn, for the question, and thanks, Perry, for the comments. Yeah, so we move on to the do's and don'ts, I suppose, of buying a property. What's best in practice, or what to look out for, what to do and what not to do?
Yeah, so I actually bought a probate property myself. I was a first-time buyer, and I said to my husband, if we can do anything possible, is buy a probate, because then you know that the chain is short. Especially if you're a first-time buyer, it will just be you and the probate property, and that's it. You're not waiting on somebody in the chain to finish their holiday or working around their work commitments. And often the properties are empty, so you can get a good idea of what you're buying and see what you're looking at. I would say the do's of buying a probate property are to be prepared to do a bit more work than you ordinarily would if someone was living in the property, to then be able to tell you about the work they've done, have all the paperwork there. The downside of a probate property is that sometimes people just simply can't find that paperwork. So you know that there's been an extension, but you don't know if building regulations were done properly because no one's been able to find the certificates. So make sure that you're prepared to do a little bit more investigation into both the state of the property and its title. Your solicitor will obviously talk you through it as well, because we have to do certain searches, particularly if you're getting a mortgage. You'll be required to do searches that will reveal things like planning permission and building regulations, or if they're not there. And I would say probably have a chat with the neighbours, because often the neighbours are there. They've been there for quite a while, and the random knowledge that a neighbour will have about a property is actually invaluable sometimes compared to what an executor would know who's very rarely visited. So be prepared to have chats with different people, and I would definitely say on a probate you want to do a survey. I would always suggest doing a survey anyway. It's going to be the biggest investment you ever do. But people I know don't want to, because it's money at the time when money seems to be going through your fingers at a rate of knots. But with a probate property, you've probably got an executor who doesn't know what work's been done to the property at all. You've also then got a property that tends to have been a little bit older, kept in the same ownership, and they may not have quite kept up to date with building regulations and things like that. And a surveyor will pick all of those points up for you. So then at least you're going in with your eyes open. We have had instances where people have bought properties and forgone the survey and then regretted it a bit afterwards because they've had to spend a bit more money than they anticipated, which is always an awkward conversation. So definitely be prepared with a probate property, have a good look into it. Chances are you may not have a boiler service, whereas if someone had been living in the property as a family home, they would have had their boiler regularly serviced. So you might have to spend out a little bit more money in your investigations. But don't be afraid to ask questions like, would they get a boiler service done? Because an executor might be happy to do that and arrange it for you. So ask as many questions as you can of different people, and try and use the internet, in particular our local authority down here in Poole. They're very good at having a good history on their website of all the planning applications. So I would always say to people, go on there, have a look. If you can't even see your property, you might be able to see what the neighbours were doing. So be prepared to do a lot of investigations with buying a probate, and just kind of expect it to maybe take a little bit longer than you hoped, because I know some people think if the property's empty, they'll be in there within 2 weeks. Chances are, if you've got a mortgage lender and all of the fun stuff that goes along with that, your conveyancer is going to take a little bit longer to get you over the line. But all good things to those who wait.
Okay. And I guess some don't.
Don't is probably fall into the trap of just thinking that everything will be done for you, because a lot of the time with estates, they're trying to save money because the executor has a liability to make sure it all goes through properly and save as much as possible. So don't expect that you will have a boiler service check or electrics tested. You might have to do that yourself. Don't expect it to necessarily happen quickly if probate is still being sorted out. Sometimes we've heard of promises being made by the probate registry that it will be done and then it hasn't. So it just disappoints people. And I'd probably say make sure that you're doing your checks as well. Maybe check it in the day when you went to see it with the estate agent, but do a drive-by in the evening as well to make sure you're happy with stuff. And of course, the important point with buying a property is that you need to remember to insure it from exchange of contracts, not completion. At the moment, with the wonderful COVID-19 situation, we're actually doing quite a lot of simultaneouses, so that's the same day, but ordinarily you would have a gap. We have had instances where executors haven't been insuring properties. And then I would say you definitely need to make sure that your insurance is well and truly in place on exchange, because that's when you're then contracted to buy the thing. So make sure that you've got all of your stuff lined up so that when you get to that point, you're ready to go.
Awesome. Anthony, anything from your side?
Yeah, I mean, buying a property, houses are designed to be lived in by humans. And if it's a probate property, it's probably been empty for some months by the time that you would remotely be close to moving in. So like Lianne was saying, that the boiler possibly will have seized, there'll be other problems. It would not be unusual for there to be issues. So definitely see the property more than once. Like Lianne said, check on it, check on the neighbours. Definitely worth knocking on doors. If there are people in close proximity, introduce yourself, ask questions. What were the owners like? And most people, are fairly open about these things. It's a nice way to find out what you'll be moving next to if you talk to the neighbours before you commit to buying the house. So yeah, those sorts of things.
Yeah, I see Mel suggests putting a spreadsheet together of all possible costs that you could be incurring if you're buying. Do you, for example, have something like that you could supply someone that would be purchasing one of the properties that you guys are handling?
We don't supply a spreadsheet like that, but it's really easy to do one, because I just did one myself, and you can usually find them online as well, where it's budgeting for moving house, because there's things like stamp duty that people forget. When we send the estimate, of course, it will then have searches, land registry fees and stuff on there, which people haven't budgeted for. So I definitely say do a spreadsheet, and things like council tax and what your average outgoings on bills are going to be. It does vary by property and the different sizes of property. So sometimes that has taken my clients by surprise a little bit. And usually you can actually find out your council tax banding for different properties online anyway. So you just need to find that out so that you're not going in there completely blind. It used to be a standard question on one of our forms, but actually it isn't anymore, because you can find it out so easily online. So I would say have a look at that. Probably another thing to mention as well when you're buying a probate is if you're buying a probate flat, you need to bear in mind that your solicitor is going to have to do probably twice the amount of paperwork, which means it takes about twice as long, because you'll have either a management company, a landlord, or a managing agent involved, which is a third party who have to supply a lot more information. And your solicitor will also be looking at the length of leases and things like that, that otherwise you wouldn't ordinarily consider would be relevant. So, and often a poor executor who's been dumped in it a little bit has no idea how long a lease is or what the outgoings are. They just had to collect all the paperwork and kind of give it to your solicitor. So listen to your solicitor, especially when it comes to a flat. because they will be going through a lease, and there's a few little nasty things that can come along with a lease that you wouldn't know until you've read it. So do by all means read your solicitor's reports about the paperwork that you get, because it will contain little nuggets in there that might cost you some money.
Awesome. Thank you. Okay. So Anthony, I think we're heading up to your part of the show on how to prepare your will in lockdown. And I guess anytime, I suppose, but we'll head on over to you.
Excellent. I mean, making a will ordinarily is, from a solicitor's point of view, a very straightforward thing. In normal times, you would ring up, book an appointment to go and see the solicitor, take your ID documents, and we would then probably spend 45 minutes running through personal circumstances, family circumstances, and financial circumstances, just to get a picture of where the clients are, and then to talk about what they want the will to do if something happens to one or to both, and perhaps doomsday scenarios as well. What happens if there are no living descendants? Where does the money go then? The COVID-19 thing has obviously thrown everything up in the air, and we found that obviously people are anxious. That sadly people are dying as we're talking, and hopefully these people have got round to finishing their wills. What we are offering clients is telephone or Skype or Zoom meetings, so that the procedure of having the interview, sending out the draft, and then potentially agreeing a final version once the client is happy can still carry on in lockdown without too much difficulty and without any additional expense. Some people are completely self-isolating and not leaving their homes for medical or for whatever reasons. Other people are more relaxed. Certainly, in order for it to be a valid will, we need two adult independent people to countersign, saying, yes, this was signed in front of me and in front of the other witness. Ordinarily, in ordinary times, that's me and my secretary when the clients are signing them here. But for the time being, we're not really allowed to have clients in this building. What we've been doing is offering clients some instructions to get neighbours to sign. It's perfectly possible to stand on your front doorstep, arrange with your two neighbours to stand in their front gardens. The will writer signs the documents, puts them on the front doorstep and steps back 2 meters, and then they come up in turn and countersign and step back in rotation, and you've got a valid will. The other thing that we've been offering, if people don't want to talk to neighbours or that's not going to be possible, we've been doing effectively meetings in our car park where we would pass the final versions of the will, or indeed powers of attorney, through the car window, step back 2 meters, where you can still see the client signing. That's a legal signature, and therefore me plus my secretary can be your witnesses if need be. And some people are still more comfortable with that. I mean, one of the massive advantages of having a solicitor write your will is that they are effectively guaranteeing the whole process from start to end, that the document does what you want, that it's appropriate to your circumstances, that we're not leaving anybody out without making sure that we protected the will as far as possible, and that because the finished document has been witnessed by us, there is a presumption that it's been done validly. And obviously, if it's your neighbours on the document signed in the middle of a national crisis, there's a few question marks. So we are advising everybody that's making a will for now to contact us when we're out of lockdown, when they are comfortable in doing so, and to arrange to come back. We will reprint the thing and have it signed and witnessed again by us, so that there is absolutely a minimal chance of a challenge to say that it wasn't signed properly.
Fantastic.
So yes, certainly there is no reason to delay. Rather than sit at home worrying, ring a solicitor, ring us at Coles Miller. We're now offering this anywhere in England and Wales, that we can do this remotely. Providing you can get witnesses, we will send you your documents. You can get the wills put in place safely.
Fantastic. And then just in terms of the property, would you advise anyone with a property to maybe have their title deeds packaged in with their will?
It's often sensible. The client's whole documents are stored in one place, and the obvious place is normally, with a family solicitor. It's the old-fashioned thing. But certainly, in Coles Miller, we will store documents free of charge. We've got many thousands of wills, we've got many thousands of title deeds. And if everything is in one place, that does make it easier when the time comes. If a client rings me to tell me that sadly they've lost a loved one, with the surname and the property address, I can see what we have done for that client in the last 20 years, what original deeds and documents we are holding, who the executors are. There's an awful lot of information stored for our clients, so it makes sense, for us to be looking after things. It's insured, and we will happily be custodians for the documents as required.
Yeah, awesome. Okay, is that it? Lianne, you got anything to add there?
Only that the similar sort of problem that we've got with land registry documents, so your transfer documents, etc., is that normally we would act as your witness for you, because we'd have you into the office, talk through everything, and then you'd sign in front of us so we could act as your witness. At the moment, obviously, COVID has changed that somewhat. So we're now checking with people whether they have a neighbour that they prefer to stay at home and maybe just see them over the garden fence and wave it at them. Or alternatively, we are also seeing people in the car park so that we can give that 2 meters distance. So it's a similar sort of thing for us.
Okay, fantastic. So we dive into the questions.
Absolutely.
Yeah.
So I guess the one that's just popped up in the comment section from Glenn, is there a delay with COVID? And I suppose it's with probate properties and without probate properties, just as a general, I suppose, in getting properties across the line and buying a property in particular.
Yeah, we did see a delay. Obviously, before the lockdown, we knew that it was coming. So we were making preparations for that, and we were starting to do more simultaneouses because you weren't sure if you were going to be able to move or not. So tying people in by exchanging and then expecting them to complete, not knowing what was going to happen in that time frame, was out the window. So we had to suggest simultaneouses. I would say that we did start to notice that less and less properties were going on the market because the agents were having problems getting around to take the photos and do viewings. Obviously, the rules then changed last week. So the government announced it on the Tuesday night and provided the guidance on the Wednesday morning. That is all online, so everyone can see it. If you just go onto the government website and type in moving house, it lists all of the different things that you now have to do to be able to move. And that doesn't just cover solicitors, it covers vendors and also the estate agents and removals people. So there are ways around it. I know the government at the moment are trying to push virtual viewings and trying to make sure that if you are going to view a probate property to see it, there's certain rules about having doors open, not touching things when you're in there, and only 2 people allowed in from the same household at a time. So they have started to move them now, and I know that there's a lot more properties going online for viewings, and that we're actually getting quite a bit more work coming through at the moment as well. So the market's starting to pick up, but yes, there was a bit of a delay because they couldn't view. However, that doesn't mean that the conveyancing side of things stopped. Actually, we were trying to get matters moving as quickly as possible so that as soon as restrictions were lifted, we could start again. And we were at that point of exchange. So we've actually been working the whole way through. So don't believe the government when they say that the conveyancers can suddenly go back to work. We were still here.
Super. So basically, once the offer's been accepted and the contracts have been exchanged, the conveyancing process will carry on as best as possible.
Yeah, so we're just holding off at the moment and then sorting out between chains the completion date. And then we're usually saying either a simultaneous or you do an exchange and completion with a very short turnaround, so that if anybody then does start showing signs of anything, it's hopefully after you've completed, so they're already moved.
Okay, cool. All right, so moving along, it comes up nicely with one of the comments here. It says, I find it frustrating in chains when there's a probate property in the chain, but the process hasn't even started. And the question, I guess, is when would be the best time to start marketing the probate property along the line of doing the paperwork at the end of the day, so that you can say, right, we sort of have got a good idea now of the timeframes. If you launch now, it'll take us this long to complete the probate, and by the time you get your contracts and all that in place, we'll be done. Is there a good time to do it? Is there a recommended time that you put in place?
I think it depends. It's actually quite complicated because there's more than one type of application for the grant of probate, some of which are very straightforward, particularly, you know, if you can use a short form application, i.e. your assets are beneath, you know, the relevant inheritance tax thresholds, the procedure is quicker. The system is moving online and we're kind of in flux at the minute. The procedures, they've just changed within the last couple of months in terms of the how to. You need very specialist advice. You know, not everybody has to pay inheritance tax if their estate is less than £1 million, but there are different rules for different types of estates depending on whether you've previously been widowed and inherited the estate and then passed away, whether or not the property that make up the estate is passing to direct descendants, so children or grandchildren, without any conditions. And it's all very technical, so that each type of application is different and will possibly have a different delay depending on which direction we need to steer in. Certainly a solicitor could tell you very quickly, you can list out the assets and the liabilities, which procedure we would have to follow and what the time implications are. And I think until you've literally got the grant of probate in your hand or been told by an expert that, you know, the paperwork will follow very quickly, you should not put that property on the market. You know, people will get fed up. They will be hoping to exchange contracts in a 6 to 7 week time frame. And you know, if probate is going to take 3 months and then you've got the 6 weeks delay, somebody in that chain will have pulled out in frustration and will feel misled. You know, and then the property goes back on Rightmove, and people that are casually watching will think there is something wrong with the property because it keeps coming back. You know, it must be something wrong with the title. Let's not go and see that one. You know, we're probably heading into a slightly challenging market for selling houses, and you don't want to be starting with one hand behind your back.
Absolutely. I suppose, and then that brings us sort of into our next question: is what is the longest probate you have seen, and how's it, you know, what's the longest you've ever been stuck with? And do you know at the beginning already, is it going to be a problematic one, or we're going to get through this with relative few speed bumps along the way?
You can never know 100% at the beginning. I mean, one thing I haven't talked about is if somebody is trying to challenge the will or say that they are owed something from the estate and there is litigation or in the offing in the background, you know, that can take years to sort out. And in the meantime, potentially you've got no grant of probate, no way to sell the property, and you sit back and let the judges decide what happens and when. Certainly, I've seen, I mean, a will could set up some complicated trust that goes on for decades or forever, and therefore the estate has to stay open, you know, until the child gets to 25, or if you've got a disabled beneficiary or somebody who can't manage money, where you're guarding the estate on their behalf. So any of those things would take forever. In terms of getting a grant of probate, the worst it got was last year. You know, I mean, I've done this for 26 years or something since qualifying. But the probate registry, literally, we had a 9-month wait before we could put the property on the market for sale, and it was just completely administration. That was exceptional. Most of them were coming back in 6 months, but still 6 months where you're still paying out for an empty property, council tax, insurance. You know, and the buildings insurance gets a lot more expensive on an empty property. You know, it's not good. Hopefully that won't happen now, but there is a danger that the probate registries are going to be overwhelmed by the combination of staff being ill and a greater number of applications. You know, inevitably, sadly, the people that are being most affected by this awful virus are the people who are later in life, who are more likely to have substantial estates that require a grant of probate to unlock. You know, and therefore it will disproportionately give extra work to the probate registries, who are now much fewer in number. So we've just got to hope they keep going. Certainly anybody that's ringing me at the moment I am suggesting that we get our head around the paperwork as quickly as possible, that it is possible to use broad best estimates for things, drive-by valuations, to enable us to be at the front of the probate queue. That's what we should be doing. I think that would be good advice to anybody that's potentially having to deal with, a property and a bereavement.
Okay, so that led sort of into the next question: is what should you do if you've never handled the probate and you've got it all been suddenly stuck in your lap and you've got to sell it? You're obviously not a professional in probate and you don't sell property for a living. But like I said, I suppose it's get that professional advice first and make sure that you can get as much of the valuations done as quickly as possible. The paperwork out the way.
Yeah, I mean, the starting point with an estate is normally, is there a will? So if a child was going to inherit, it would normally specify an age. If it doesn't specify an age, it defaults to 18. If somebody hasn't made a will and they die, then something called the intestacy rules govern who gets the estate. And, again, if you're a single person with a child and you haven't made a will, and single, so you're not married, the estate defaults to your biological or adopted children in equal shares on their 18th birthdays. But it's very, very easy to get these things wrong. And if you get it wrong, whoever is administering the estate, can potentially be sued, become personally liable for any negligence. So, again, get advice. Executors are entitled to proper and sensible legal representation. At Coles Miller, we've got a huge range of expertise and specialists that can help you. So if you think that you need help, ring us. Have a free chat. We'll always do a free half hour for any aspects of an estate. So if you are stuck, you're not on your own. We have been open throughout, and we are still open now. It's just that the offices can't have clients in for the time being.
Awesome. So I suppose we're at the last question that I have. When it comes to the decision making in the sale of a property, now we're obviously we're putting an offer. Who needs to make that decision? So is it the executor, or would it be the heirs, or does the executor need to go and get permission from someone before they can make a final decision on the sale of the property? Say there's 2 or 3 heirs. And are they not, I suppose, just have to do what's legally in the best interest of the estate?
Yeah, I can, if you like. I would always take instructions from the executor. So they have the legal power under the grant, and that is what I need to provide to the buyer's solicitors to prove that they can sell that property. So they will be signing all the paperwork to sell that property, and that includes the forms. Sometimes, though, the beneficiaries do have a better idea than the executor. So if the beneficiaries are the deceased children, but then the executor was their sibling because they didn't want the children to have to deal with it, sometimes the executor will say, actually, do you mind if the paperwork is also signed by my nieces and nephews, because they're the beneficiaries and they know their dad's property or mum's property better than I ever can. So, and we will do that, and we'll explain to the buyer solicitors how they've come to sign it, but it all still needs to be signed off by the executor because it's their legal responsibility, and they will be the ones that sign. But we always say it's a good idea for them to have a chat with the beneficiaries. Don't just roll her off and go and do it all yourself. Keep them involved because it's less likely to then need to dispute about property prices, etc. And we at Coles Miller will still take phone calls from the beneficiaries of those estates if they want to phone and just say, where are we with the sale? Provided, obviously, we haven't been told that they're not allowed to know for whatever reason. But we'll just try and keep everybody involved. So at the end of the day, it is the executor's responsibility, but I would always say keep everyone in the loop, have that chat, because then it saves a lot of complications down the line.
I think it's important that the executor keeps the beneficiaries on side, that effectively they're performing a role, and that you need to make sure that you're doing that properly, and that involves keeping them in the loop. Yes, these are the offers we've had. We are tempted to accept this offer. What do you think would be a typical discussion that an executor should have with one of the beneficiaries? The beneficiaries could be charities as well. Again, if they're getting a percentage of the estate, there are certain things that you need to do and certain steps that you ought to be taking to consult them. You don't want any beneficiary turning around after you've sold the house and accusing you of selling it to a friend at a discounted price. So, you know, be very, very careful. The executors are the fall guys if something goes wrong.
Okay, right. So the buck normally stops with them. Okay, so I think we've at it for a bit of a while, so I think let's start wrapping up. How do people get hold of you if they need you now, as it is?
We're in the office 9 till 5, Monday to Friday, obviously not bank holiday Monday. You know, or email us. All of our information is on the Coles Miller website, which is coles-miller.co.uk. And yes, you can email either Lianne or myself. Our links are on the website as well with our profiles. So, you know, if people think they need help, contact us. We can probably help you. And if we can't, we can put you in touch with someone who can.
Okay, cool. I think what we'll do is we'll put your contact details down in the comments as well. You'll link to your website, and everyone's got direct access to it. Yeah, thank you very much, guys. It's very informative. I see a lot of people have gotten some value out of this. A lot of my colleagues will be able to use this information going forward. It'll help us in our jobs to get people moved on to the next chapter.
Yes.
So yeah, I guess that's it. Enjoy your weekend and enjoy Monday, bank holiday.
Everybody, thank you.
Thank you.
Okay, cheers, guys. Bye.